Good morning, America. Good afternoon here in Hungary. Now we have a presentation, we have a conference, a webinar that is organized in the frames of Ferenc Mádl Institute. And this webinar is part of a bigger project that analyzes the religious symbols and freedom of religion and freedom of conscience in the Central European region. And this is a dissemination event with three presentations and I hope a fruitful discussion. First, I would kindly ask Professor J Strang to give his presentation. Then Balázs Sanda will give a presentation on freedom of religion in pandemic times. And finally, I would like to have some words of vaccination. And we have a discussant, István Sabjanics, also from Pázmány University, and he will start the question and answers. So, Professor Strang, I kindly ask you to give a presentation.
Yeah. Thank you, Dr. Ching. And as you said, good morning from America and good afternoon there in Hungary and elsewhere. I'm looking forward to listening to your remarks. I know a fair amount about the American context. I'm looking forward to learning more about the Hungarian context. So this afternoon, what I propose to do is first provide a brief background of religious liberty law in the United States. And there's a theme to the portrait that I'm going to paint. So it's a short time frame, so I can't cover all the nuance. But the theme I'm going to highlight is that in the United States, religious liberty protection in the federal constitution and then in state constitutions was largely the product of, at least for the time period, relatively robust religious pluralism in the United States. And my claim is going to be that as that religious pluralism, I'm going to describe it as being broad but thin, that most Americans up until the 1930s or so were primarily Protestant Christians. So even though many Americans disagreed on theological propositions, they agreed about many aspects about how one should live the good life. And I'll give some examples of that. And so that led to relatively few disputes over the scope of religious liberty during that time period, with one prominent exception that I'm going to highlight. With increasing immigration in the United States, first primarily from Catholic countries, and then including Jewish and Muslim immigrants, and then most recently, the rise of a large number of non-religious Americans, this religious pluralism that was the birthplace for religious liberty in the US has now come, and this is going to be my claim, has now come to put significant pressure on religious liberty. And the COVID-19 pandemic was, I think from the majority of the justices' perspective, was a place where they saw, for the first time in a really broad-based and from their perspective, aggressive way, significant restrictions on religious liberty in a way that I think is prompting them in a case that's before the court in the upcoming term, City of Philadelphia versus Fulton, is going to prompt them to change the law in a more religious liberty protective way. So first, some background. The United States has always been a religiously pluralistic country. The colonists prior to independence came from lots of religious backgrounds. Many of them were motivated to come to the United States because of these different religious backgrounds. They wanted to be away from religious restrictions, for example, in the United Kingdom with the established Anglican Church. And this religious liberty included not just what we might call standard or traditional, or at least in the US we would call magisterial Protestant Reformed denominations, but a lot of other non-magisterial denominations as well, including distinctively American types like the American Baptists, and even a small Jewish community. There was also a scattering of Catholic Americans, primarily located initially in Maryland, but then as immigration increased throughout other parts as well. Now, these colonists disagreed on many theological propositions. It actually caused a fair amount of tension that was for the most part resolved amicably through people kind of settling in different areas where their local communities represented their religious views. And these Protestant sects, although they disagreed theologically, had a lot of agreement on many aspects, including one in particular. So when the current US Constitution was adopted in 1789, it had no protection, or other than one kind of clause, the religious test clause, had no protection for religious liberty. And one of the things that the vast majority of Americans agreed on is they wanted protection for religious liberty. And that would mimic what all, I think, but two states at that time had in their own bills of rights, because Americans were concerned, given the experience with the home country, the United Kingdom, of pressure being put on religious liberty. So the Free Exercise Clause was adopted, and it's part of the First Amendment to the US Constitution. And the Free Exercise Clause protects something called the free exercise of religion from government prohibitions on it. And it was adopted because Americans were concerned that this new federal government, which was a new creature under the sun, and many criticized it as being potentially too powerful, would have the power and would use that power to restrict religious liberty. And Americans wanted religious and government interactions to be primarily a local phenomenon. And as I said in my introductory comments, up until the 1930s, there was not a lot of litigation over the meaning of the Free Exercise Clause. There was one case from 1830 called Tarrant versus Taylor, which had just a very oblique reference to free exercise. But the first major case wasn't until 1878, which I'll describe in a second. But I think the main reason why there was little litigation for the Free Exercise Clause was because there was a broad-based consensus among Americans about the way that Americans should live their lives, despite their theological disagreements. So, for example, the vast majority of American states had what we today call Sunday closing laws, where the law would prohibit, with a few exceptions, for example, with medical personnel, would prohibit conducting business, public or private, on Sunday. And that was not challenged. Actually, it wasn't challenged until the 1960s, because Americans thought of that as natural. And it would be the case if the vast majority of Americans shared the same basic theological outlook. And so it wasn't until we started to have, for the first time, a large number of non-religious Americans that Sunday closing law started to seem unnatural, and we had responses to that, with one exception. This 1878 case is called Reynolds versus United States. It deals with my understanding is a uniquely American phenomenon, although now has spread throughout the world, of the Mormon Church, the Church of Jesus Christ of Latter-day Saints. And the Mormon Church had a number of theological propositions that even by American Protestant standards were unconventional. And one of them that raised a lot of criticism was the practice of polygamy, so having more than one wife. And that was something that the religious leader, Joseph Smith, had enjoined on his followers. And Congress, many states passed laws prohibiting polygamy. The United States common law prohibited polygamy. And the federal government then in 1862 passed a law called the Morale Anti-Bigamy Act. And what it did was it forbid polygamy in any of the federal territories, including Utah, which was at that point a territory in the home of the vast majority of Mormons. And there was a prosecution by the federal government of a gentleman named Reynolds for having more than one wife in violation of the act. It was a felony prosecution. He was going to be put in jail. And he sued, claiming that his religious beliefs required him, on pain of hell, to have more than one wife. And nobody challenged the sincerity of his religious beliefs, but the U.S. Supreme Court found that his religious beliefs did not exempt him from the generally applicable prohibition on polygamy. And what's relevant to my point here is that the court made the claim that polygamy was something that had always been a part of Western law, Western tradition, part of Roman law, common law, American state law. And it was something that was, and this is my claim I'm making, natural to a culture like the United States that had a broadly Protestant basis. And so the religious free exercise clause did not protect one from those kind of unconventional practices. In the early 20th century, the Supreme Court began slowly to edge towards greater protection of religious liberty. And my claim is that it was because of a response to increased religious pluralism in the United States. Because as I said, for the first time, especially by the 1920s, you had a significant minority of Americans who were Roman Catholic, approximately 20% at that time. And you started to have non-de minimis numbers, so in the single digits for the first time, percentage of Jewish Americans. And so this caused what seemed to be natural. So as one example, public schools in the US, which are officially non-religious, at that time had Bible classes that people of a broadly Protestant background saw no problem with, but American Catholics would see a problem with because the Protestant Bible is typically different than the Catholic version of the Bible. And I think the best example of the Supreme Court moving towards greater protection is a case from 1972 called Wisconsin versus Yoder. And it involved the Amish religious community. So the Amish religious community, for those who may not know, is basically people who, among other religious tenets, believe in a very simple way of life that includes a non-mechanized, non-technological lifestyle. So it's basically living life like an American farmer from the early 1800s. It's kind of a generalization of their lifestyle. And one of the components of the religious beliefs was that they did not send their children to formal education beyond 8th grade. And up until the 1960s, that worked pretty well, where you had Amish children who would go to a public school up until 8th grade, learn reading, writing, and arithmetic, as we say in America, and then go back and, as if that person was a woman, learn how to be a wife and mother, and if that person was a man, learn how to be a farmer or a laborer. But then, beginning in the 1960s, many American states began imposing mandatory education laws up until the age of 16, so beyond 8th grade. And Wisconsin was one of those states. And Yoder was an Amish father whose children were not going to school beyond the 8th grade, and he was prosecuted by Wisconsin for the truancy of his children. And the Supreme Court ruled in favor of Yoder, saying, and this is at the point of the high point of protection for religious liberty, that Wisconsin, although it had a good goal, which was making sure that all Wisconsin citizens were adequately educated to be good citizens, that Wisconsin's goal was not needed to require the Amish children to go beyond 8th grade, because Amish children, based on the statistical evidence before the court, and just honestly based on my own anecdotal experience, Amish children tend to be very good citizens. And so the Wisconsin was restricting religious liberty without a really good purpose to do so. And that's where the law stood up until around 1990. So really out of the blue, there was a case called Employment Division versus Smith, whose author was, ironically or not, I think ironically, Justice Antonin Scalia, who was widely known as being one of the most religious members of the US Supreme Court for a long period of time. And the opinion dealt with two employees being fired for their religiously inspired use of a hallucinogenic drug. It's a hallucinogenic mushroom. The plaintiffs in the case, or the petitioners in the case, were members of what's called the Native American Church, and it's one of a number of churches of various backgrounds that includes Native Americans and others that practices a variety of religious, including transcendental states, often induced by drugs or medicine. And so they challenged the Oregon law that made it a crime to utilize this religiously inspired drug. And the Supreme Court said that your activity was not protected. So moved away from Yoder, moved away from protection, and said your activity was not protected. And the reason the court gave was that the Free Exercise Clause protected only government regulations that were targeted at religious activity. In other words, the regulation said you can't do that activity because it's a religious activity. And the Oregon law said, we don't care why you do the hallucinogenic drugs, you just can't do them, or are you going to go to jail? So in other words, it was neutral in the language of the Smith court, in the language of Justice Scalia's court. And based on the thesis I'm presenting today, Justice Scalia's, one of the parts of his reasoning is actually, I think, ironic, which was Justice Scalia's argument was, in a religiously pluralistic country like the United States, we can't have religious exercise being a get out of jail free card, because it is the case that Americans will create religious belief systems that will allow them to exempt themselves from a variety of obligations, like paying taxes. There have been cases where people challenge paying taxes. And so in 1990, the Supreme Court shifted towards that really unprotective status for religious liberty. And that's where things stood, I would say, up until the early teens of this century. So let me give you just a flavor. So up between 1990 and until around 2013, the US Supreme Court worked within the framework of Smith and seemed to be generally okay with doing so, even if there were some hints that at least some of the justices were unsatisfied. So for example, in 1993, there was a case called Church of Lukami Babalui versus Hialeah, which is a city in Florida. And that involved the Santiera religion. The Santiera religion is a syncretic religion of African religious traditions and Catholicism that originated in Cuba. And many immigrants from Cuba from the revolution settled in Florida and practiced the religious belief system, which included animal sacrifice, which is very unusual in the United States. And so the city fathers of Hialeah passed a series of ordinances that didn't expressly say no religious sacrifice, but in practice made it impossible to do religious animal sacrifice, while simultaneously allowing for the killing of animals for other purposes, such as human consumption. And so the court said in that case that the city of Hialeah law was not neutral. Even though it didn't expressly target religious activity, it in fact targeted religious activity, and therefore was struck down on that basis. And so that's 1993. And things seem to kind of basically stay in that area of Smith up until the early 2000s. In the first case that I read, that I thought made it suggest to me that a significant minority of the justices are unhappy with Smith and its relatively low protection for religion, was a case from 2012 called Hosanna Tabor versus EEOC. This involved a Lutheran church that had a school, a private religious school, K through 8, in Michigan. And the church considers all of its teachers, K through 8, as not being maybe ordained ministers, but still ministers of the gospel in helping as pedagogues for the young children there. The school fired the teacher. I'm not sure what the reason is for firing the teacher, and I don't think it was anything necessarily nefarious by the school. There was a parting of ways, and the teacher sued the school for violation of of a federal anti-discrimination act that prohibits firing somebody on the basis of disability. And the church defended itself on the merits, but also said that the federal government cannot apply this anti-discrimination law to a church and how the church deals with its own employees and its own ministers. Again, not formally ordained, but in a broader sense. And the Supreme Court ruled in favor of the church. Now, that's a really hard case to fit under Smith, because everybody agrees that federal anti-discrimination law is not targeted at religion, that it's not meant to just pick on religious organizations. And so the court articulated what today has become known as the ministerial exception, which means that there's some kind of amazing synthesis that's not fully clear yet between the Free Exercise Clause and the Establishment Clause that requires federal, state, and local governments to not regulate a church and its relationship with its ministers, broadly conceived. And the court didn't say really anything about Smith, because Smith would lead to the church losing in this case, other than a one sentence in one footnote saying this case is different than Smith, but not saying why. And so that struck me for the first time, that there's something unusual in the law there, where Smith should apply and should have led to the opposite result. And since that time, in every case that's come before the Supreme Court has purported to work within the Smith framework, but has done so in an increasingly strained way. So for example, in 2017, there was a case called Trinity Lutheran Church versus Comer. It came out of Missouri, and Missouri had a government program where people could, organizations could apply for basically free chopped up tires. And you use the free chopped up rubber tires for things like playgrounds. So that way, when children jump off a swing set, they don't get hurt because the rubber is soft and therefore leads to them not being hurt. And Missouri did not include Trinity Lutheran Church in the free program for the sole reason that Trinity Lutheran Church was a religious organization. And Missouri, like approximately 35 other states, had what are called Blaine amendments, named after a famous US senator, that prohibited government aid to religious organizations. And the Supreme Court said that, again, working within Smith, that the Blaine Amendment was targeted at religious activity, and therefore the Blaine Amendment in the Missouri Constitution was struck down. And that's where things stood in a series of subsequent cases up until today. And so bringing it now to today, in my last 9 minutes, I think it's clear that the Supreme Court is unhappy with Smith, and it's only a question of, is Smith going to be overruled, or is Smith going to be narrowed in such a way that it's materially transformed? And I think there are 3 major reasons for why the Supreme Court is unhappy with Smith. So first, today on the Supreme Court, there are 6 justices who personally are religious and view religion as something that's fundamentally good, not always good, but fundamentally good, not just for the individual believer, but also for American society, that they view religion and religious people and religious organizations as being a positive aspect of American history and therefore worthy of protection. Second, the justices see increasing pressure on religious liberty in the United States. And this pressure comes from a variety of sources. I think the most important one is demographic. For the first time in American history, we have about 20 to 25% of Americans who say that they're not religious. Now, being not religious doesn't necessarily mean that you think that religion is bad, but at least in the American context, because of issues like same-sex marriage, a large number of non-religious Americans view religion not just as benign, but as something positively harmful, as something that's positively antithetical to civil rights issues. And so religion should be regulated, and in fact, maybe should be regulated significantly according to this demographic chunk of Americans. And just so everybody's on the same page, when I say 25% of Americans, that distribution of non-religious Americans is not even across the United States. So for example, Nebraska has the highest church attendance rates, and I would bet that non-believing rates are probably 5% there. But Massachusetts, for example, is relatively equivalent to many European countries with a significant majority of Massachusettsans not being religious. And there's an example of this before the Supreme Court in the upcoming term, the case of Fulton versus City of Philadelphia, where Catholic Social Services had worked with the City of Philadelphia for literally decades on placing children in foster families with foster parents. The City of Philadelphia required organizations like Catholic Social Services to, quote, certify that prospective foster parents were in fact good parents. Catholic Social Services, following Catholic theological beliefs, refused to certify for couples, people who are not married or people who are in same-sex marriages. And the City of Philadelphia then terminated its adoption relationship with Catholic Social Services. And the Catholic Social Services now is appealing that case up to the US Supreme Court. So I think what you see there is religion is viewed by the City of Philadelphia, at least in that instance, as something that's harmful and should be restricted. Now, the third reason why I think a majority of the justices are significantly inclined to change the law in this area is COVID. That the response to COVID by many governments across the United States showed the justices that government was very willing to restrict religious liberty, including in many cases where the restrictions appeared unnecessary and treated religious activity less favorably than comparable or similar secular activity. And the Supreme Court was inundated with these cases. These cases were coming very fast and furious to the Supreme Court, and they presented very aggressive restrictions on religious liberty. And so I'm going to turn to that part in my last few minutes. The COVID restrictions, I think, have shown the justices that government will treat religion as unvaluable and, in fact, as harmful. In the US, nearly all COVID restrictions come from state and local governments, and these responses have varied dramatically. So some states like Iowa, where I'm originally from, had relatively modest restrictions. And then other states, typically on the coasts, so California and New York are probably the most prominent examples, have very robust restrictions, including on religious activities. And lower courts typically have been unsolicitous to religious liberty claims. And so I'm going to use two examples to show you kind of the restrictions that have come to the Supreme Court and the Supreme Court's response. So one of them from last year was called Diocese of Brooklyn versus Cuomo. So Governor Cuomo was the governor of New York, and he issued an executive order that restricted public gatherings depending on the incidence of COVID in the immediate area. So there were red areas, orange areas, and green areas. And if you were in a red area, like where the Diocese of Brooklyn was, you were restricted to having only 10 people allowed in your religious gatherings. Now, one might say, well, 10 people is all that could be safely fit. But what the diocese pointed to the Supreme Court was that in the same executive order, Governor Cuomo allowed exemptions for so-called essential businesses. Now, essential businesses included things like grocery stores, which many of us would think are essential, but also included things like acupuncturists and campgrounds and hardware stores, things that maybe are good and valuable, but aren't what we might think of as essential. But the key point is, and this is what the Supreme Court hinged its opinion on, is that Governor Cuomo was saying that comparable secular activities, like going to an acupuncturist, were subject to less onerous restrictions than religious activities. And so the Supreme Court enjoined Governor Cuomo's order, saying that you can't treat religious and non-religious activities unequally. Now, that's still, at least theoretically, within the framework of Smith, because the court found that religious activity was being treated unequally and therefore not neutrally, which was a precondition for Smith. And the same thing happened in 2021. There was a case called Tandon versus Newsom. Newsom is the governor of California. He issued an executive order, and in his executive order, he likewise restricted activities, and in particular, he restricted activities at homes. In the United States, we have a phenomenon of home church, and in the home churches, they were only able to have, I think, 3 families. While at the same time, home churches were restricted. Home businesses, many home businesses were not restricted. So you could go get your hair done at a hair salon at a home business, and it wouldn't be restricted. And so the court there, in what I think it was a very rhetorically aggressive opinion, and one that was very clear, given which I found surprising because of the constraints under which the Supreme Court is operating chronologically, enjoined Governor Newsom's order, and said again that if you have religious activities that are being restricted and non-religious activities that are not being restricted, that are comparable to the religious activities, then the Supreme Court is going to enjoin those that order that restricts the religious activities. And just to give you a flavor of the aggressiveness of the justice's views about these restrictions, I'm going to quote from a concurring opinion by Justice Gorsuch. And here he says, "The only explanation for treating religious places differently seems to be the judgment that what happens there just isn't as essential as what happens in the secular places." And he says, "In recent months, certain other governors have issued similar edicts. At the flick of a pen, they have asserted the right to privilege restaurants, marijuana dispensaries, and casinos over churches, mosques, and temples." So he's saying, he's articulating what I'm suggesting, which is that they see religion is widely viewed as not being that valuable, or in the context of COVID being harmful. And the Supreme Court sees that the current Smith framework is not protective. And so I think that in the Fulton case before the Supreme Court this upcoming term, the Supreme Court is very likely at minimum to narrow Smith. And I think there's a significant chance, maybe even now a majority chance after COVID, of the Supreme Court rejecting Smith and going back to the earlier pre-Smith robust protection for religious liberty. So my theme this afternoon has been that the United States' religious liberty protection was born in religious pluralism, that the increasing religious pluralism in the late 20th century has caused pressure on religious liberty, as many Americans have come to view religious liberty as at best benign and at most harmful, and that the Supreme Court now has a number of justices who view religious liberty as being valuable and are now seeing that the need for increased religious liberty protection. So I'm looking forward to questions from our commentator and to hearing my colleagues' comments as well. Thank you so much.